Google paid $26 billion in a single year to make sure you'd never consider a different search engine, and a federal court document proved it. Today we go through that document. DOJ filing cover page, close-up, Google logo, number animation, $26 billion. Record this verbatim, no improvisation. Target, under 25% audience drop in first 30 seconds. In 2023, the U.S. Department of Justice filed one of the largest antitrust cases in American history against Google. The allegation: Google turned its search engine into a monopoly. The weapon it used wasn't better technology, it was money, payments so large that no competitor could ever match them. This video is not opinion. Everything you'll see is sourced from DOJ filings, court transcripts, and the judge's published ruling. Sources are in the description. In the 2000s, the search market was genuinely competitive. Yahoo, AltaVista, MSN, all serious players. Google's technical superiority was real, but that's not where the problem starts. Point 2. The default deal mechanism. The problem is what Google did next. It didn't just say, "We're better, use us." It signed a deal with Apple. On every iPhone, in Safari, in Siri, Google would be the default search engine. In exchange, Apple received a share of ad revenue. According to court documents, that payment reached $18 billion in 2022 alone. Visuals: iPhone Safari search bar close-up to money flow animation, Google to Apple to $18 billion. Label. Point 3. The scale. The same structure was applied to Samsung, Mozilla, and other browser makers. The result: users never had to make a conscious choice. Google was already there. It was the starting point. If these documents are useful to you, the like button is how this channel knows to keep making them. Now the critical question: what's actually wrong with that? Don't large companies always pay distributors for placement? They do, but Section 2 of the Sherman Antitrust Act prohibits it when the intent is to prevent competitors from entering the market. That is exactly DOJ's case. Point 4. Exclusionary conduct. The court documents use the term exclusionary conduct. Google's $26 billion in default payments structurally blocked rivals from reaching users. Bing, DuckDuckGo, or any hypothetical new entrant. None had the budget to compete with that number. The market was walled off before the race began. Animated bar chart. Google versus Bing versus DuckDuckGo market share, 2015 to 2024. Arrow competitor locked out animation. Point 5. Judge Amit Mehta's ruling, August 2024. In August 2024, federal Judge Amit Mehta issued a 277-page ruling. His finding: Google has illegally maintained a monopoly in the markets for general search and search advertising. This is one of the most consequential tech rulings in U.S. legal history. The numbers that emerged from the case documents put the scale of this monopoly in concrete terms. Some of this data had never been public before the trial. Point 6. Market share. Google holds an 89.2% share of general search in the United States. On mobile, that number climbs to 94.9%. In antitrust law, the threshold for monopoly status is generally recognized around 70%. Google sits nearly 25 points above that line. Point 7. Ad revenue gap. Google's search advertising revenue exceeded $175 billion in 2023. Bing's total search ad revenue, approximately $12 billion. Google generates roughly 14 times the ad revenue of its closest competitor. Point 8. The cost to consumers. According to the DOJ complaint, this monopoly artificially inflates advertising prices. Every time you search on Google, the elevated ad costs in a non-competitive market are ultimately passed through to product prices you pay. The monopoly isn't just an abstract legal concept. It has a price tag. The defense: what Google actually argued. Voiceover. Google's defense runs on two main arguments. This channel is obligated to present them fairly because every claim here must be grounded in documented positions, not selective framing. Defense argument 1. Google argues that users can change the default search engine at any time. Switching to DuckDuckGo or Bing takes one tap. The switching cost is effectively zero. Users choose Google. they aren't trapped. Defense argument. 2. Google also argues that its search quality is genuinely superior and that its default position was earned through performance. The payments it makes aren't a monopolization strategy. They're investment in a market position the product deserves. Voiceover. Judge Mehta evaluated both arguments and rejected them. His ruling states, the default position creates a structural advantage, not merely a preferential one. The theoretical ability to switch does not neutralize the practical exclusionary effect. Production note, this section should use a measured journalistic tone, slower pacing, less editorial energy than the rest of the video. Let the arguments breathe before the rebuttal lands. The remedy, what happens now? Voiceover. The liability phase is over. Google lost. The real fight is now in the remedy phase. What actually changes? Point 9. DOJ's demands. The DOJ asked the court to order Google to divest Chrome and to ban default search agreements on Android. These demands target the structural core of Google's business model, not just a fine but a forced restructuring. Point 10. Google AdTech case. In a separate proceeding, the Google AdTech case, the DOJ is seeking the divestiture of DoubleClick. As of March 2026, that case is active and a decision is pending. Point 11. Historical parallel. We've seen this before. In 1984, AT&T was broken into 7 companies by court order. In 2001, Microsoft was found liable in a similar antitrust ruling, but survived the remedy phase intact. Will Google look more like AT&T or Microsoft? The answer is still being written. This channel is building a series on AT&T, Microsoft, and Google, the 3 cases that define American antitrust law. Subscribe so you don't miss the next one. This case is asking a question that goes beyond legal procedure. In a digital market, is competition even possible, or do network effects and default placement permanently lock in the winner? Whether DOJ wins a full breakup, a partial remedy, or only a ban on default deals, each scenario produces a different internet. In the next video, we'll look at exactly how each outcome changes your search experience, ad prices, and which companies survive.